1891, where they define federal government. The system of government administered in a state formed by the union or confederation of several independent or quasi-independent states, also the composite state, so formed. So therefore, this is where I get the idea that the Confederation, the Articles of Confederation, still are in existence because it is what forms the United States in Congress assembled, and you can see that in the Articles of Confederation. So when you look at the Articles of Confederation, you see that the states formed the United States of America, and they convened themselves in Congress assembled, and then they formed another union called a federal union called the United States in Congress assembled. Two different places, two different things. In the preamble of the Constitution, you see this again. We, the people of the United States, which was created by the Articles of Confederation, do these things for the United States of America. The definition goes on. In strict usage, there is a distinction between a confederation and a federal government. That's why they have two separate documents, a Constitution and the Articles of Confederation, because one is federal and the other one's a confederation of states. The former term denotes a league or permanent alliance between several states, each of which is fully sovereign and independent, and each of which retains its full dignity, organization, and sovereignty, though yielding to the central authority controlling power for a few limited purposes, such as external and diplomatic relations. That was an example. The other thing that they do is they from the Constitution, the United States is supposed to administer the federal lands for military purposes. In this case, the component states are the units with respect to the Confederation, and the central government acts upon them, not upon the individual citizens. So there is no individual citizen authority given to the federal government. So the federal government has no authority over the individual citizens of the state. It only has authority over the federal citizens on the federal lands, such as those people who join the military. In a federal government, on the other hand, the allied states form a union, not indeed to such an extent as to destroy their separate organization or deprive them of quasi-sovereignty with respect to the administration of their purely local concerns, but so that the central power is erected into a true state or nation possessing sovereignty both external and internal, which means that the federal government holds some sovereignty, and that sovereignty is for declaring war and peace, for example, and administering the affairs of the federal lands, the military. Okay, and that's basically all they're supposed to do in the Constitution, aside from some foreign matters. While the administration of national affairs is directed and its effect felt not by the separate states deliberating as units, but by the people of all in their collective capacity as citizens of the nation, which is our protection, not to force us into paying federal taxes, because the federal taxes were something that the federal people were supposed to pay when they were on federal lands, but also those federal people had to pay the state taxes when they were on federal lands in a particular state. So if a person is in the military in Virginia, he has to pay the state of Virginia taxes, but also the federal taxes, because he is both a person of the state and the federal government. However, people not in the military, not on federal lands, do not pay a federal tax. They only pay their state tax. The distinction is expressed by the German writers by the use of the two words Staatenbund and Bundesstaat, the former denoting a league or confederation of states, and the latter a federal government or state formed by means of a league or confederation. And you can see this in Black's Law 5th, 1891, and feel free to read it for yourself. I will provide you a link, and here is the cover of the book, A Dictionary of Law containing definitions of the terms and phrases of American and English jurisprudence, ancient and modern, including the principal terms of international, constitutional, and commercial law, with a collection of legal maxims and numerous select titles from the civil law and other foreign systems, by Henry Campbell Black, 1891.